Patricia Baumgart. I'm the Director of Human Resources for the County of Missoula.
Now, Patty, in instances where there is a complaint that's, say, been filed with the Human Rights Bureau out of Helena, what is the procedure? What steps are taken to see that through to a conclusion?
Well, normally once the complaint is received by the Human Rights Bureau, they provide the county a notice that that complaint has been filed, and they provide the county a particular period of time in which they can respond to the allegations made in the complaint. The county normally responds to that in writing, and like I said, has a limited time during which they can do so and provides any information they feel is relevant to the complaint. At that point, an investigator is assigned by the Human Rights Bureau, and that investigator forwards one copy of the county's response to the complaining employee. And that employee is then provided an opportunity to rebut or respond to whatever the county has provided as far as its defense against that particular complaint. At that point, there's kind of a softer rule about the county is entitled to read the rebuttal, and the county can assert a right to respond to the rebuttal, so kind of a second-round response. At that point, the investigator takes the process forward, and they are on some time guidelines that I believe are set in statute, and they're fairly rigorous for those investigators. And they take whatever course they feel is necessary to investigate the claim, probably talking to the complaining individual, talking to people at the county who are presented as witnesses, and then they have certain benchmarks within the law that they have to meet to address whether, for example, the person who has filed the complaint has standing to make such a complaint, and what their findings are with regard to the complaint. And once they issue those findings in a formal manner, then depends on what those findings are is what course of action is then available to the county.
Okay, so let's just say that the Human Rights Bureau says that there is a genuine issue here that needs to be resolved. What does the county do then? Do they have a choice of going to trial or settling, or what are the choices?
Well, the Human Rights Bureau, if they issue a notice to the county that they believe that they are accountable for the discrimination that they have discriminated against the individual, this is where you probably need to talk to our county attorney's office about. It goes into a more legal format. This whole investigative process is really more considered almost an informal investigation process because it's done by an investigator. An employee does not need an attorney to participate in this process, and many employees do not use an attorney to participate in the process. And often at the conclusion, if there were finding against the county might engage in, for example, a settlement discussion about how this would be resolved. The matter can be referred, I believe, to what's called a contested case hearing. And beyond that, I really think I'm going to have to refer you to the county attorney's office because we're getting into an area out of my depth because it's all involved in actual legal procedures.
Sure. Well, let me ask you this. When someone does file a complaint like this, is there any chance that they could lose their job because of it?
That would be considered a form of retaliation, and retaliation is a protected area under Montana's Human Rights Act.
So that couldn't happen then?
Not based on the fact that they had filed a human rights complaint. No, definitely not.